I've done that, and that was great. This was not my one. It was great for me to write it
Right.
and build out what we needed.
98% is about them. Well,
67, right? So, but she got up there and she killed it, and we're in federal court, and the judge looked at her, and then he like sort of looked at me, and then he like sort of looks at the partner that we were working for, and then he looked at the plaintiff's table, and he said, "We're gonna go into recess, and I'm gonna think about this." Like, he didn't deny it outright. And all of a sudden we were all going, "Oh my God, we're gonna win a J-Mal motion." Right? Because she delivered, right? Like, I delivered a physical product that explained the law, but she delivered.
Because to get one of those means, I mean, it's not a directed verdict, but it's
as close as you can get.
Yeah, it's close. It's like it's almost like we're talking about sports. It's almost like pitching a no-hitter, or the other team maybe scores 10 points, or if they score 100, you score 300. Like, it's
right.
just
it's
a
yeah.
knockout.
It's right, and I liken it to stay with the sports analogy, like the beautiful catch over the wall, right? Like, oh, here we go, we're gonna go into the next portion of trial, and then it's like, whoop, nope, we're right here. So what happened with that was the judge was deliberating. He hadn't even brought the jury back in from lunch. He wasn't sure he was going to, because what if we win the motion? Then it was over. And they settled. Right there.
I bet.
After about 30 minutes, they settled for a fraction of what the last offer had been in mediation.
And that is a moment where law school or anything can't teach you, because when
right.
you say something like, when you do judgments as a matter of law, and the judge is like, I'm gonna go in chambers, that's really your moment. That's when the Harvey Specter in me would come.
100%.
That's when you could. I'm not even
gonna lie. I was looking for a bourbon. I looked up. I was like, I think I have a drink. Like, I've never even seen this happen before. You know, and he was like, "This is pretty good." Like,
that's when
we're in a good spot.
That's when you sit back in your chair, like, I don't know if the camera can see me, but it's like,
yeah. Yes, hello.
Yes, I think you want to reconsider.
Right. Yeah, it was wild. And the crazy thing about it too is. But the crazy thing about it was, we didn't get the firm-wide shout-out because it wasn't technically a defense verdict.
Okay.
But the client was thrilled because they hadn't gone over the budget of what they were allowed to offer. And the risk of going to verdict is 3 times what the settlement was, plus punitive damages and attorney's fees. Then you're looking at an appeal, right? So when you think business, and it's really, really, really hard to sort of internalize this, I think, as a business litigator, you can have the winning argument. You're like, this is what we need to do. Here we go. And then your client, the entity, makes a business decision based on money, time, reputation, but right, PR that has to happen, new hire. I mean, there are so many different calculations that go into it, and they can say, look, if we can get to this number, settle it, I'm done. And it's just, and it can be devastating because no, I can win. But they are making decisions based on what they know about their business. They're not making, and their business budget, they're not making decisions necessarily on, your golden argument.
Right.
And that can hurt sometimes.
and one of the things that, and I won't mention what case, but just in general, and we're going back to procedure, is that, let's say you don't settle and now you get a judgment. And let's say it's without prejudice. or it is prejudice, right? Now we have claim preclusion, issue preclusion. We won't get into that.
Yeah.
But the thing would be now, no one can come and use that case against you again, or to use in another matter to press another issue because you settled. And that is another nuance again that
Right.
you
I see what you're saying. So, and all of that comes down to how well your settlement agreement is written.
Right.
So get you a writer.
I have a screenwriter.
Yeah.
Yeah,
Yep, see? There you go.
Yeah.
There you go. And just so like everybody who's listening knows, like issue preclusion or res judicata, those things are essentially the civil versions of double jeopardy, right? You can't be tried for the same murder, crime, you know, if you've been found not guilty, they can't come after you again. Although there's like some weird case in Ohio where they, anyway, it doesn't matter. This poor guy was on trial for like 4 times. Off every single time. Wild. And they still kept trusting. Anyway,